I'm going to call the April 14th, 2016 meeting of the Marin Local Agency Formation Commission to order. We'll start with the roll call. Rachel, can you do that for us?
Yes, I may.
Good.
I'll begin. Chair Blanchfield.
Here.
Commissioner Arnold.
Here.
Commissioner Condon.
Here.
Excuse me, Commissioner Baker.
Here.
Commissioner Connolly.
Here.
Commissioner Murray.
Here.
Commissioner Phillips.
Here.
Alternate commissioners, Commissioner Burdick.
Here.
Commissioner Cayos.
Here.
And Commissioner Sears. Commissioner Warner. Let the record reflect that Commissioner Sears and Warren are not present.
Thank you. It appears we have a quorum and thus conduct our business this evening. First matter, I'll take it as the consensus of the commission that the agenda is fine for our meeting this evening, unless I hear differently. Not hearing differently, we will proceed and follow the agenda as sent to us. Next is the open time, the time on our agenda in which members of the public that wish to address the commission on matters that we don't have scheduled for discussion this evening may do so. Any issues they may have, the staff will get back to them in writing, or we will schedule it for a future meeting. And I don't see anyone that wishes to address the commission in the open time, so I will move on then to the consent calendar, which is a very large one. We have 7 items on the consent calendar, including minutes of our last 2 meetings, and then the minutes from September 9th, our last meeting dealing with our strategic planning workshop. An update on the evaluation of other post-employment benefit liabilities, the update to our strategic plan that came out of our workshop, progress report on the work plan we have underway, also approval of the meeting dates the remainder of the year on once every 2 months we will be meeting here on Thursday at the San Rafael Council Chambers at 7 o'clock. And also authorization to provide new furniture for our new quarters at 1401 Los Gomez in San Rafael. And listing of current and pending proposals. We have 3 current proposals that the staff is working on to bring to us. 5 pending proposals that are out there ready to come, and then 2 additional possible proposals. So all in all, 7 items on the consent calendar, and I will entertain a motion to approve the consent calendar. Any commissioner wishes to pull something off so we can discuss it separately, we will do that as well.
Move to approve.
Second.
Motion by Commissioner Phelps and second by Commissioner Arnold to approve the consent calendar. All those in favor signify by saying aye.
Aye.
Any commissioner opposed? Any commissioner abstaining? The motion passes. We'll move then to our public hearing matters. The first is the adoption of the proposed work plan and the operating budget for fiscal year 2016-2017. Keen, you want
Yes.
to present that to us, please?
Thank you so much. So as referenced, this public hearing is for the commission, really to take the first of 2 ultimate steps in setting a game plan for the upcoming 2016-17 fiscal year. And this means tonight we've brought you by way of your budget committee a draft resolution that, if approved, would do 2 things. One is that it would approve a proposed work plan where you'd be setting resources and activities for the 12-month period. And then equally, you'd be approving a proposed operating budget to fund those various activities. And again, the idea tonight is, and under state law, the commission has really asked, do you believe the draft before you is sufficient as a first go, and if so, then we send it out for formal public review, and that includes sending it to our 42 local funding agencies with the idea that we'd come back to you on June 9th for final action. So with that, and hopefully the agenda report does a good job of kind of walking you through the various policy issues in both documents, what I thought I'd do is just take maybe 4 or 5 minutes, and again, on behalf of the committee, to highlight what I think are some of the key takeaways. And in order to do that, I would suggest it probably would be best if the commission took a look at attachment 1 to the agenda report, which, and by the way, I realize parenthetically we failed to label the attachments in the report, so I will talk slowly as you find the draft resolution. A resolution that has 2 exhibits. Exhibit A being the proposed work plan itself, and then of course Exhibit B being the actual budget document. And as you go through that document and you find that resolution, let me start off with the proposed work plan. It certainly follows in response to the direction we got at the February 17th workshop. Yes?
King, can I break in for a moment
Please.
and show the commissioners what I understand to be the work plan
Correct.
that you have? Now, it's back in there. It's towards the end of the document in this section 8.
Okay.
So start at the back, and you will find a multicolored spreadsheet,
This is it, Gary, after number 8.
and it is entitled, the first one, the work plan, is entitled 2016-2017 Work Plan with our famous logo in the upper left-hand corner. And I will give you a second to find that.
Thank you, Chair.
Oh, I see we're getting close. There, Carlos. Right there. You've got the work plan here.
Yeah, the adoption of proposed work plan. And it's behind all that before the orange page.
It's sort of like an Easter egg hunt, but
Mine's all out of order. I don't know why. Okay.
So now that we've gotten a little workout finding the document, and again, I apologize for that. If you take a look at a couple of pages or one page in, you'll see, as Chair Blanchfield noted, a proposed work plan. And again, it responds to the feedback we got at the February 17th workshop, which I would characterize as stay proactive. And that's very much what the work plan sets out to do. We've identified a total of 30-plus specific projects that we are suggesting to the Commission be your goals for the fiscal year. 30 projects that are divided between these 3 function areas of the Commission, right? You have a planning side, you have a administrative side, and then, of course, you have the regulatory side. It's the 2 former, the planning and administrative side, that gives you the most discretion. So that's where the 30 proposed projects we have listed are. And as you look at it, you'll also see a couple of new categories. Yes?
I just want to make sure the commissioners have found it so they can follow along, because it's, you all have, if anyone hasn't, let me know and we'll get it there. And it looks like everybody's found it. So pardon me.
Oh, no.
Please proceed.
Thank you. And so 2 new features to the work plan itself. First is, and based on earlier feedback, we've incorporated a priority category, okay? And this is divided between those projects that we think are high, meaning we need to get to them, those that we think are moderate. Yes, they're important, but not necessarily critical. And then the third and final category being low. Still a merited project, but if resources get strained, those are the items that we would anticipate kind of getting off of our radar and perhaps slipping to the next year. As you go through this item, certainly the Commission might want to scrutinize what we have labeled as high, moderate, or low to make sure that you are in agreement. The other new feature to the work plan, and again based on feedback we got on the 17th of February, was just to make it very clear what is a brand new work plan item versus what's been rolled over from the prior year. But as I mentioned, there are a number of high priority projects that we've listed. I think the agenda report enumerates them beginning on page 3, but just for the benefit of getting those that I think are most time intensive on your radars, this includes establishing our very own and standalone accounting system. The background to this is Marin LAFCO for decades has been tied to the county's accounting system. It has worked well for us, but as the county does its own transition away from SAP to Tyler, we have been politely told that we're getting a Tesla in terms of all the bells and whistles necessary for department or accounts that have hundreds of variations. LAFCO has 2 accounts. We really just need a Corolla. So it might make more sense for us to, again, go our own way at this point, whether it's with QuickBooks or I know Chair Blanchfield identified another software system. We're open to it, but I think the goal is we go independent and find a system that works for our kind of scaled down needs. We're also adding a project to look at the merits and demerits of perhaps contracting with CalPERS for pension services, in particular to look at would there be any measurable cost savings for LAFCO, given we've already established a relationship for our other post-employment benefits. Also, and again in response to some feedback on the 17th, we've added some community workshops that staff, or more specifically Rachel, would lead, where we go out into Ross Valley, into Marinwood, and when we prepare these draft reports, instead of inviting everyone for the first time at the commission meetings, we do some proactive engagement to explain ourselves, explain some of the rationale, so we learn and understand the feedback before you're subjected to it at the first time on the dais. And then finally, what I would suggest is going to be the most intensive activity. We are due for a municipal service review up in Novato. And there are a lot of different issues going on in Novato relative to LAFCO's interests, and it does happen to parallel with the City of Novato's own general plan update. So that's fortunate timing for us, and I know that your staff and Novato staff have already been discussing some issues, both pressure points and synergies with respect to the fact that the sphere of influence that you or your predecessors established for Novato and updated, I think, back in 2002, doesn't necessarily correspond to the T with their own urban growth boundary line. And so there's probably a good reason to have some discussion and at least make sense of the baseline, if not to maybe consider making some adjustments, whether it's LAFCO adjusting or perhaps you politely signal to Novato, maybe that their urban growth boundary line could adjust. So that's the work plan in terms of the high priority projects. As you go through to the next exhibit in that resolution, you will see where the committee is proposing the resources come to fund those activities. And of course, that is our operating budget, an operating budget that lands on a recommendation that you raise operating expenses this year, again, consistent with having a rather aggressive proposed work plan, by about 13%. And that you would take LAFCO's budget from $464,000 this fiscal year, and you would go to $523,000 next fiscal year. So that's about a $60,000 difference. Now, what does that $60,000 buy the commission and in turn the public? Well, certainly some enhanced service and supply services. In particular, about 2/3 of this increase is going directly to non-labor accounts, and that's highlighted by funding a new website, bringing in our own IT person at Marin LAFCO. To date, we've been dependent on either friendly visitors to LAFCO and or our former office landlord's IT person to corner them and ask them some questions. I think it's time that LAFCO have their own person on board. And then finally also, we just moved, so we need to accommodate a slightly but certainly necessary larger space. Now the remaining third of the expense increase does go to labor, but it doesn't increase staffing. You're still at 3 full-time employees, but it does contemplate a 3% cost of living adjustment consistent with what the county has lined up with its unrepresented employees. So that's what the budget buys us. Now, what does it cost? Well, obviously, literally, it cost us $60,000. That, in turn, we look to our funding agencies to cover, with the caveat that the committee is recommending that we apply a $25,000 reserve credit to help kind of smooth these costs going forward. In terms of the big three, LAFCO, as you know, has funding from the county. They take a third of the budget right away. And then City of San Rafael and Marin Municipal, those three together with the county, they represent 50% of our budget. And I have conveyed the budget to the city manager, county administrator, and the general manager. And I'm hopeful, and I think so far so good, that they understand where this is going. So that's the document before you. Again, you have a resolution that, if approved, would take in a proposed scope of, a work plan, and then the operating budget with it. Just a few, last editorial comments. The legislature gives you a lot of work to do, and I think that's reflected in your proposed work plan. I think we've whittled it down, though, to manageable bites, as we put in the agenda report. Not everything that we talked about at our last workshop is in the proposed work plan. For example, the reorganization review of North Marin Municipal is not in the document. The scheduled service review of the Fairfax-Ross Valley communities is not in the review, just because there is limitations to what we can do. But we think we can get to what we've provided before you. And then finally, just for context, there's a couple of other attachments that you'll see in your agenda packet. One is a comparison of what other Bay Area LAFCOs are budgeted at. And again, this is just for context. So even if you go to $523,000, which is the recommendation, you're still a very good deal relative to other Bay Area LAFCOs. And then there's a couple of other spreadsheets that show the history of the budget. And then finally, just for the benefit of projection, what each individual agency, and again, you have 42 funding agencies, would likely see if this number ultimately gets approved come June 9th. So with that, I would defer to the committee members, members Arnold, Phillips, or Murray, if they'd like to add anything, but we do have a recommendation to approve with any changes. Thank you.
Okay, did any committee members wish to speak on this matter?
I think he covered it. Gary, go
He
ahead.
Okay, Commissioner Phelps.
Thanks. I have a really basic question, so I apologize, but I know you've got a lot of experience in this area, and I don't. So I'll ask. I know that there are a number of consolidations that are being considered throughout the county. They're being discussed and perhaps acted upon at some point in time. For example, I know that Larkspur and Corte Madera fire departments are having some discussion, the councils regarding the fire departments. What I'm not clear on, and what I appreciate your enlightenment upon, is whether or not this organization has any role to play in those considerations.
So the answer is maybe, and it depends on what the fruits of those discussions are. If it is a discussion in which City X and City Y are talking about a joint powers agreement to combine a particular service, well then, outside of commentary, this agency would not directly be involved in the decision-making. However, if Agency X and Agency Y wanted to establish a fundamental governmental change in which a special district or a subsidiary district to a city were created to oversee that service, well, yes, under LAFCO law, they would have to come to this commission, file an application, and then under LAFCO law, you would have to review it on its merits. So it depends on what is potentially being proposed.
So at least as I understand it, it sounds like it's not either required or even undertaken by LAFCO.
If
The
it's a
example that I gave.
If the example you gave sounds like a joint powers agreement, so then that would not come to LAFCO under existing law.
And there's a difference, of course, between consolidation and a JPA.
Correct. So under a functional consolidation, which it sounds like, at least I understood the premise to be, a functional consolidation does not come to LAFCO. A political consolidation would.
Okay, thank you. Appreciate it.
Okay, any other comments of the committee? Keen, just so it's straight for me in laying out a roadmap, what we're going to do with this, we have your report, the report of the committee, and we open a public hearing to hear from the public on this, because this is a proposed work plan and a proposed budget that is to be circulated to the funding agencies and the general public for comment that will come back to us to be reviewed by the committee, and the committee will then give us a final recommended work plan and budget, which we will assumably adopt by resolution and then forward that on to the county,
Correct.
at least the budget part.
Correct.
Okay. So tonight, what you're asking us to do, and I guess the committee is too, is to review and approve this as a proposed work plan and a proposed budget for public review.
Correct.
And public comment.
Yes.
And it will come back to us at the May meeting?
June 9th.
June, oh, that's right. Okay. So, fine. I understand that now. Any questions that the commissioners may have before I open the public hearing? Any questions commissioners may have of the staff's presentation and report? Seeing none, I will open the public hearing, and anybody that wishes to address this matter, the mic is open. Okay, I have no cards, and not seeing a stampede up to the lectern. We'll keep the hearing open, or do we close it at this time?
Yeah, so you would, this is a standalone process, so you'd close it.
Yeah. Okay. Do I have a motion to close the public hearing on the draft? You all understand?
Close the public hearing.
Okay. Motion and a second to close the hearing and to submit this draft or proposal on to our funding agencies and to the general public. All those commissioners in favor signify by saying aye. Aye. Any commissioner opposed? Any commissioner abstaining? Motion passes, and the proposed work plan and the proposed budget will go forth. Yes.
Chair,
Great.
on the resolution, do we need to take action on?
Well, I'm not clear. I'm not, Keen, I'm not clear. We're passing a resolution to move this on, or do we wait?
No,
until-
so you do have a resolution before you to formally adopt.
Okay,
I
so
apologize.
I just want to make clear that the commission's action to adopt the proposed work plan and the proposed budget is based on the resolution, but I want to make sure that the maker of the motion understands that to be that they are seeking to approve the resolution that is attached to the staff report and is entitled Resolution of the Marin Local Agency Formation Commission adopting a proposed work plan and budget for fiscal year 2016-2017.
Mr. Chair, I'll friendly amend my own motion.
Okay.
To approve the resolution that also approves the proposed work plan shown as Exhibit A and also the proposed operating budget in Exhibit B. as
Okay.
noted in the resolution.
How about the proposed work plan as identified, because we also don't have an Exhibit A or Exhibit B. So it's attached proposed work plan and the attached budget, proposed budget. So, and the maker of the second agrees to that as well?
Yes.
Okay. So I believe we've already voted on that.
We are good.
This is included the resolution, I think, didn't
Ye-
it?
Yeah, this is to include the resolution?
Yes.
Okay. And so, all those in favor of including the resolution into the motion, signify by saying aye.
Aye.
Aye. Any commissioner opposed to that action, any commissioner abstaining, and that is passed then. So the resolution is adopted, and the proposed work program and budget will go forth. The next item is an old friend that keeps coming back. The reorganization to detach 91 Glenside Way from the San Rafael Sanitation District and annex it to the Las Colinas Valley Sanitary District in a companion sphere of influence amendment. Keen, do you want to
Well, absolutely. And
refresh our memory?
And Chair, you phrased it well. This is an old friend that needs a little love and care through the warm greetings of LAFCO. But as mentioned, this hearing has been continued a couple of times. It originally came to you back in December, and it is ultimately for this membership to consider a rather unique proposal in that the applicant/landowner is really looking for your green light to switch public sewer service providers for his existing single-family residence located at 91 Glenside Way in the unincorporated community of Los Ranchitos. And in particular, what the landowner applicant is looking for approval is for you to make some boundary and sphere adjustments that will allow him to essentially detach the property out of San Rafael Sanitation District and then concurrently go into Las Colinas Valley Sanitary District. Now, the reason one would want to do this rather kind of odd reorganization is actually rather pragmatic. The goal here for the landowner's perspective is he can go ahead and eliminate an existing private pump that right now he's dependent on lifting affluent up over hill down into San Rafael to Rustic Way. If the reorganization were to be approved, he could do away with the operation and space dedication of this pump and just simply gravity feed to Las Colinas Valley Sanitary, a district whose sewer main, after a couple of decades of incremental expansion, is now right outside the property owner's right of way. Now, you will recall staff came to you in December and said this proposal makes sense. It checks off most of the boxes with respect to the Commission's policy as well as state law, but we came to you with a couple of conditions that we really liked that we thought would better perfect this proposal relative to your growth management interests. One of those conditions generated a little more discussion than we had anticipated, and I know that's why the applicant's representatives, Fred Devine and Chris Skelton, are here this evening, and that was we initially said, well, to accommodate and make sense of this detachment, where a property owner is now walking away from a sewer connection in line to San Rafael, it would make sense that we have that property owner provide written release of the easements that they have with 3 neighboring property owners that currently provide access to the San Rafael sewer main. Now, in presenting that recommendation to the Commission, some commissioners thought that was okay. Some others thought it didn't go far enough. And I know the applicant wasn't thrilled at all. So your direction to us was, can we see about a workaround with the applicant? And if so, come back to you. So with that as the context, we return today with what your staff believes is a good workaround, okay? And it's identified, at least in bullet point form, beginning on page 4 of your staff report. And essentially, we take the concept of what we had talked about before, and we just get away from talking about having any written release of easements and any talk about of a taking. And we just have the applicant record an agreement that runs with the property that attests to certain outcomes or activities. In particular, that they would maintain the easement in the sewer line, that they would attest that they wouldn't use the easement and the line for any future sewer flows to San Rafael, that they would identify the neighbors who they have easements with in case there's any damages that are caused down the line and are sourced back to the neighbors' properties, and then finally that we would require that they create an insurance mechanism of up to $1 million for each occurrence of any future damage. This was an agreement that really kind of got developed between our council and the applicant's council, at least in terms of ideas. I know our council's A-OK with this. I think it's a good solution. I appreciate that Mr. Skelton, who's representing the applicant here, may have some lingering concerns that at least merit some discussion before this commission, if for no other reason, to help staff understand where you are on this, because this is new to us. You know, I've been doing LAFCO a long time, and I don't recall this type of proposal. So that said, while it may be a little messy, I think we're close to a solution, but I'll defer to the commission on that question. This is, again, an open hearing, so you just need to return to the hearing. And again, I know we have Chris Skelton and Fred Devine representing the applicant in attendance.
Okay, so the hearing was kept open.
Yes.
Open, yeah. I think before we go and ask the public to speak on this, it would be helpful to have the applicant and/or his representative respond to what is proposed by staff.
Yeah, there. He needs one. Oh, never mind, he has it. Yeah, we're okay. We got it.
Yeah, he
Got
probably
it.
was. You never can tell. Well, it's a delightful picture.
Good evening, Commission. Good evening, Commission. Can you hear me now? Thank you, Keen. I am that old friend, and I'm Chris Skelton here to represent Mr. Muldoon, the owner of 91 Glenside Way. Like I said, thank you, Keen, for the staff report. Aptly stated, the owner was not entirely convinced that the initial proposal was appropriate, and we have worked tirelessly with LAFCO outside counsel and Keen in trying to work our way around some of the issues. A little bit of background color. I know it's already in your staff report, but I'll just highlight a couple of items. You know, this application has been before the commission for almost 5 months now, and at first it was seemingly straightforward. It was a request for reorganization. It apparently is unique, although when you think about it pragmatically, in Marin County, it shouldn't be that unique in that we're a hillside community, and infrastructure has evolved and grown over the years where certain things weren't in place, 20, 30, 40 years ago, and now they're pretty accessible. So the reason why I'm here tonight is we're not convinced that the proposed conditions of approval are appropriate, and that they're neither reasonably related nor roughly proportional to the impacts of this proposed project. And it is a project. The only really appropriate condition that can and should be placed on the approval of this reorganization application is the first bullet point. That the sewer pipe be capped at the property line, and that the current and future owners of 91 Glenside Way, they stop sending effluent over the hill to San Rafael Sanitation District until such a time that a new application for reorganization back into San Rafael Sanitation District may be submitted and approved through LAFCO. I don't have a crystal ball. I don't know if that will ever happen. I think reasonable minds would suggest that it probably won't. But again, we're not interested in foreclosing a future opportunity, especially one that was privately bargained for between individual parties for valuable consideration. I am an attorney, and so I want to very briefly bore you with a little bit of legal framework, and I apologize. When I was first asked to review this easement issue, my initial question was to the owner, why go through the hassle, the time and effort to keep these easements and their corresponding rights as they are? And, upon further reflection, the more appropriate question is, why is LAFCO so eager to go through such great lengths to meddle with private property rights? And I apologize. I don't mean to sound antagonistic, but when you distill down this issue, that's what is happening. There are 5 easements in place that were bargained for by the predecessor in interest with the corresponding neighbors for a sewer easement. Centerfell Sanitation District, Las Colinas Sanitation District, they were never a party to those negotiations or a party with privity of contract to the actual agreements themselves. And so from a organization and management perspective, LAFCO's fingerprints really should remain only in that public right-of-way where the property lines stop and the public right-of-way starts. No matter how hard I tried, I simply could not squeeze this answer to why meddle with the private property rights into the framework of regulating the formation and development of local government agencies and their municipal service areas. After the December hearing, I did prepare a brief legal analysis, provided it to Keene, and it was forwarded on to outside counsel at Vespes and Krieger. Unfortunately, no response was prepared to it, but I think implied is a negative pregnant that the outside counsel must have agreed with the legal analysis that the original proposal for an abandonment of the easements was an overreach, and that it truly wasn't reasonably related or roughly proportional to the impacts of the application. As Keene mentioned, instead, we were presented with an agreement, and the agreement suggested a memorialization of certain conditions of approval. They are identified, the 4 main bullet points in the staff report. Outside counsel provided no support for the proposed conditions to the agreement, and I maintain that they're equally impermissible and they're, borderline tantamount to the original proposed abandonment, just in a softened form. Furthermore, the agreement was apparently prepared before even a review of the private easements had taken place, since at least 2 of the conditions of approval far exceed and go beyond the framework of any of the original easements. Specifically, it's bullet points 2 and 3 that are especially problematic. None of the existing easements in place have an insurance policy of $1 million required. It's simply not there. To require a nuanced condition that is often a challenge for private parties to bargain around as a condition of this reorganization application seems too far afield, and like I said, is impermissible. Now, only one of the 5 easements that is in place has an indemnification and hold harmless agreement. Again, to require such an agreement and unilaterally impose it on the owners now, it's not a runaround of this takings argument, it's a runaround of the originally bargained for agreements. And I remind you, valuable consideration was paid for these. And then I would suggest that bullet point 2 is simply unnecessary. The duty to maintain an easement, that's a restatement of an existing obligation, except that obligation is between the private parties. Why restate it in a new and different way with a new party that's not in privy of contract? It seems to sort of muddy the waters, and it doesn't add clarity. It actually clouds the issue. So simply stated, the sewer easements at issue, they're private easements. They were bargained for between the private parties. There's no objection from the property owner to capping the pipes at the property line. I think that is appropriate and reasonable. That solves the problem. No effluents going anywhere when the pipes are capped. Going beyond that and taking it a step further, it's not appropriate and impermissible. There's a practical outcome of this that I think is important just to wrap your head around. The easements, they're between the private parties. LAFCO wasn't a party to it. The sanitation districts weren't a party to it. I would suggest to this commission that the proposed agreements, if they were made a condition of approval, that the property owner enter into this agreement with LAFCO, that LAFCO would be entitled with and create this enforcement authority and or duty if under a very unlikely scenario. And again, I don't have that crystal ball, but unlikely scenario that some private property damage was created through the use and enjoyment of the easements, the servient tenements, the property owners who are burdened by this easement, whose private property may be damaged, they could and would look to LAFCO to enforce their private property rights, because now LAFCO is in privy of contract, all right? And they are the ones who have the $1 million insurance policy enforceable. So it actually, it adds a whole layer of challenges in the future. These private property owners may come to LAFCO if a $1 million insurance policy lapses or isn't renewed or something happens, and say, now you guys need to enforce that provision so that we can maybe go back and try and go after the property owner for some damage to the property. Is that the role of LAFCO? Is that what is meant in LAFCO's objective about encouraging the orderly formation and development of local agencies? I don't think so. Now, from a practical approach, and this was an outstanding question at the December hearing, the sewer easement, it's a black pipe. Looks just like this. It's 1 inch thick. 1.5 inch thick. We're not talking about a 4-inch pipe. We're not talking about a 3-foot wide culvert. The likelihood of failure of an existing pipe like this out in the field is quite minimal, de minimis, non-existent. They just don't happen. And I'm happy to pass this around. This is a gas pipe, yellow. The only difference is it's black.
Excuse me, so the black pipe is the sewer pipe?
Yep, and I passed around pictures
Yeah,
of that
I
black
just
pipe,
wanted to
and
make
this
sure.
is exactly what it is out in the field. And you can see it with the tape measure, and it literally looks exactly like this.
What kind of material is it, do you know?
It's a plastic polymer.
What kind of, it's all kinds of plastic.
I unfortunately,
Low pressure, gravity,
I
makes a difference.
I don't know what that is. But I would suggest that it complied with whatever the standard was at the time that it was put in. So I understand that there were prior questions about removal of the pipe, filling the pipe with concrete, or identifying means to address unforeseeable future failures or subsidence from the pipe. I believe that the removal of the pipe issue has been resolved. Filling the pipe with concrete is tantamount to removing it. It's simply another way of saying you cannot go back there without incredible effort and more likely than not, severe costs to remediate. Filling a pipe with concrete, in the event that they had to go back and reuse that easement area, you'd end up redigging, retrenching, tearing out any landscaping or other improvements that are occupying the surface area. That is not acceptable or appropriate in this circumstance. So, in summary, we ask that this reorganization application be approved this evening without the unreasonable and illegal conditions that were previously proposed. LAFCO has no direct interest in these private easement rights, and it would be best served by avoiding any precedent of unreasonable interference with private easement rights, especially ones that don't touch and concern the formation and development of local agencies. The proposed conditions for this application are a complete outlier, and for good reason. They should be struck from any resolution adopted in favor of this project. So we ask that you only approve the project with bullet point number 1, that you cap the pipes at the property line, that you don't send effluent beyond the property, and we leave it at that. Bullet point number 2 is a restatement of existing conditions that exist in purview of contract with the private property owners. Bullet points 2 and 3 are simply unreasonable and misplaced. So I welcome any questions you may have. If I don't have the technical expertise to answer them, Fred Devine, the architect, is here this evening to answer them. And thank you for your attention.
Mr. Skelton, thank you. I'll ask any commissioner, Commissioner Baker, anyone else, and Commissioner Conley. First, Commissioner Baker, your question?
Yeah, another one. Yeah, several things. You started off kind of, and this gets away from your thrust of your points, but the 4 or 5 months that have ensued were not on LAFCO's part. I think the ball was kind of in your client's court pretty much at that time. And they kind of, I think, voluntarily pulled it back a couple times to work things out. We wouldn't hear for a couple months, maybe 3 months. So LAFCO hasn't been holding this thing up. It's just kind of, that's my understanding. But anyway, to some of your points here, it wasn't concrete. It was grout. There is a difference. Concrete's got rocks and so forth. Do you have some understanding what was behind that to fill it, if that were to happen?
Yes, I do understand that it was intended to avoid any pipe failure that might lead to subsidence or other property damage.
Yeah, something, but not a matter to, as you suggested, and that would be the case. If it were filled with some solid material, yes, it wouldn't be ever functional again to restore the service up above. But the purpose of this, for some of us, you're an attorney, I'm an engineer, and I've done projects in that area and many others on hillsides that have movement, earth movement. Slides, sometimes it's very subtle, very long-term, and it's not often enough to damage a house or a driveway, sometimes. But sometimes there's some underground movement, enough to kind of tear pipes, rupture them. In my past professional life, that's happened a number of times. Doesn't happen every day, but over a period of years, it can happen. This may be there a long time, it may not, but once it's there, and I would kind of characterize it, even if it's owned by the same person as it is today, it's kind of an orphan. It's not something that's being used. And that area, Red Rock Way, Glenside, there's been a history of earth movements along Ranchitos Road, some of the other roads, and it's an area to be careful about and to leave. And I can see it. It's not a 3-foot pipe, not a 2-foot, not even 12-inch typical drainage pipes. It's a very small little sewer line. But strange things happen. And I've seen it here and there, whether it's South Marin, Central, or North Marin, where something's put in years ago by one owner, and it's superseded maybe later by something else. And not always, but sometimes, there's movement, water gets in, it follows this circuitous route from the upper street down to the lower street to Glenside, or maybe some intervening point where there's been a slide, some movement. and the water comes down into some, it looks like there's 4 or 5 properties in there. It's not, yeah, okay. So it's not just, your client's property that's contiguous to Glenside on the one end, in Rustic Way. There were these other intervening properties, and maybe it'll work fine. But to me, it's a risk that this is the time, rather than just leaving it as sort of an orphan pipeline, this is the time to fill it with grout or do something else that's more of a positive corrective factor, so that if there is some separation and the pipe gets disrupted or the joints come apart, it happens. And water gets in, doesn't go down, and cause some problem to either to the new owner, perhaps maybe your client, somebody else, or one of these other poor parties, the adjoiners. I just think and I will concede maybe it's not within the normal realm of LAFCO practices, but I think we're also looking at the public interest here. And to me, and I've got a kind of maybe background a little different from most of my colleagues here, the idea of just kind of capping the ends and leaving it there for and accepting the risk that there's going to be some movement on that hillside that breaks or twists or separates at the joints perhaps. And, we'll all be long gone. You'll be gone, your client probably. And then somebody else will say, what in the world is that pipe doing there? Why didn't they, not maybe taking it out. That's kind of extreme, I concede. And I don't think we ever suggested that. That may have been, Mr. Devine may have interpreted that. At least I never said that. I never heard that up here. But somehow to do something more positive, to fill that thing, or maybe at certain select intervals, to put in like grout. And there's different types of materials. It's not concrete. And yeah, it's a nuisance. It's going to cost a couple bucks, but it's not digging the whole thing out by any means. And I just think in the public interest, particularly the interest of the 4 or 5 properties, it just is inappropriate to just kind of leave the cap the ends, walk away and leave it. Where I think it's a fair chance that one of these days it's going to come back to bite one of these people down this low Rustic Way.
Could I ask him a question, Jack, a question?
Yes,
what
you
you
may, if that's all right with Commissioner Conley. Yes, please do.
Are you saying that you support all 4 bullets?
Well, I would have come up with slightly different ones, but I wouldn't, I think in the interest of being cautious, I wouldn't just start taking these out. You'd like to have them all taken out.
So, and I can address that as well.
Bullet point number 1, we're okay with. I would suggest bullet point number 2 is a restatement of the existing conditions and is completely unnecessary. In fact, it just adds a new party to that existing condition, and so it actually ends up confusing the matter.
Well, maybe the bullets need to be kind of rephrased, reorganized, or something like that. The specifics in those, but you just start taking them out because they're offensive, they're burdensome. I just think it's passing the buck down the road to some other person in there.
May I respond to the question as they come? That way I don't end up losing track. I'm trying to take notes as I go, but happy to take questions.
Honestly, I think I can tee up some of the questions that may.
How
in a way
about
that
letting
may be
Commissioner
helpful.
Conley take a shot at it, and then you have a rebuttal of them both?
That'd be great.
Commissioner Conley.
Thank you, and I appreciate Mr. Skelton's remarks and also Commissioner Baker's to at least, I think, begin to define what we're talking about. I think the question in my mind still remains, though, what exactly is LAFCO's interest in this matter? And what is the proper role of LAFCO in addressing this type of matter? One possibility is, are we trying to avoid liability on behalf of LAFCO? In other words, if LAFCO sets a chain of events in motion by a decision relating to, that could affect private easements, is LAFCO somehow on the hook? There should be a legal answer to that, and I haven't seen it here. Commissioner Baker raised a more general concept, public interest. Again, that is pretty broad. While intuitively it makes sense to some degree, I doubt that it goes so far as that LAFCO would intercede in all events that would otherwise be more characterized as between private parties. So I think there's a legal limit to that. The only real delineation I saw here in the packet was a statement in the analysis section saying, this includes providing documented assurance, and this is basically saying why the recommendation is being made. This includes providing documented assurances to the Commission the easements and associated sewer line vacated by the reorganization will remain appropriately managed in step with Marin LAFCO's interest to produce effective municipal growth management. That's pretty broad. I mean, basically, you could stick any activity under that statement. So I find that unpersuasive as well in this case. I think another legitimate issue was raised about if we enter this contract, who would then enforce it? LAFCO? When in fact it's probably more suitable for a private party dispute. So what I would recommend is I think there's no dispute that bullet point 1 is appropriate. And I'm not really hearing any dispute that bullet point 2 is appropriate, because essentially whether you call it a restatement of Hornbook law or on balance, to go to Commissioner Baker's point, the situation should be maintained. I think that's also legitimate. 3 and 4 do seem like they're outside the scope of what LAFCO would appropriately be involved in this situation, unless you, Keen, or someone else can provide me with a reason why we should be.
So Commissioner Conley, are you beginning to formulate that as an alternative motion?
From 1 and 2 and not 3 and 4.
3 and 4, so it would be to accept the sphere change,
Correct.
accept the reorganization to detach the territory from the San Rafael Sanitation District and annex it, I'm reading directly from number B, and annex therein to Las Colinas Valley Sanitary District, subject to 1 and 2,
Correct.
and that's it.
Right.
I would second that. Commissioner Phillips, excuse me. I heard you on that, but I was,
So,
Ray, go ahead.
basically, we have 2 sanitation districts. We have a property that's gravity fed, it's going up gravity. Only reason this pipe is here is because of a failure above in years past. This line needs to be put in for sanitary service. Now, the applicant wants to remarry, to attach to a new sanitation district, but then what we're hearing tonight is, hey, we'd still like to be married to this other group, Santa Fe Sanitation Department, by having this pipe remain there. So it's, to me, on the face of it, either you are or you aren't. So are you going one way or not? And if you want to keep that pipe there, then you do need to protect the public interest. As Mr. Baker's aware, Commissioner Baker and myself, you know, we serve, and Mr. Kios as well, serve on sanitation boards. And one of the main concerns here in Marin is inflow I&I. And this could be a tremendous source of I&I, not only to that homeowner directly into his home, but also to the public interest if, for some reason, it flows into neighboring properties or into public street. So to not look at that concern, I think that does need to be reviewed. However, who's appropriate to do that? And what I'd say is if you truly want to not be married to Santa Fe Sanitation and you truly want to be married to Las Colinas, then you need to go to Las Colinas and the district engineer, general manager there, and make sure that things are protected so there's not new sources of, as you mentioned, it'd be effluent, and it might not be effluent. There might be other things, there might be worst-case scenarios that Mr. Baker has experience with that he's trying to explain that might not be detailed in the bullet points that Commissioner Connolly has indicated that we may need to work and massage a little bit to make sure it's appropriate. But there are these overarching public concerns that, in my opinion and view, and I think some of the others are expressing here, are a LAFCO concern. And how that is vetted and detailed, it might go to those particular sanitation agencies with the experts to review these systems. So I'm not sure if Mr. Devine or others have done that, but what I'm hearing is you'd still like to be connected to both systems, and that doesn't seem to be appropriate at all.
Well, if you look at bullet points 1 and 2, though, I think that's addressed. I mean, 1 specifically says, shall not use easements for any purposes tied to sending sewer flows to Santa Fe Sewage District or Sanitary District. Covered. 2 is the applicant and any successor will maintain the existing sewer pipe within the easements to avoid damaging the surrounding properties in perpetuity until the lines are removed. Well, no, my motion is that they would have to agree to 1 and 2.
Yeah, I mean, we have a motion and a second on the table now. I'll just say, I'm concerned with what is LAFCO's responsibility under our legislation, and if we are acting as a city council or a planning commission or something like that, I think we would look at this much different. And I'm worried that we are getting into what I would call really land use decision-making at a very fine level. It's conditions you put in land use permits. And I'm not sure that that's where LAFCO belongs. And so that's why I second what I thought was Commissioner Connolly's way of really solving the problem as we see it.
I would like to briefly interrupt.
Well, I'll tell you what.
Okay.
Before you do, let's see if we have agreement with the motion. If not, then we'll move on to something else. Commissioner Phillips.
Thanks. Well, I'm certainly respect Damon's views, and particularly as it might apply in this particular case. I'm a little bit concerned because we started by hearing that there was discussion between the parties, and therefore I was a little bit surprised that there was an agreement coming to this body. And furthermore, since we were apparently, LAFCO was represented in that discussion, I'd be interested, and I haven't heard a rebuttal yet, if you will, by Keene, as to why these items were included, and after the presentation, if you still feel they're appropriate or not.
I agree. I would want to hear.
So through the chair, I was involved, and our council with Best and Krieger were involved in discussions with Mr. Skelton. But when we got to the point of trying to find this workaround, where we went away from asking for the release of a release from the easements to this agreement, if you will, that was something that was discussed specifically between our attorney and Mr. Skelton. And the takeaway that got inferred to me was these are the bullet points that we agreed to. This provides LAFCO, kind of the maximum protection given our interest. And parenthetically, and I appreciate Mr. Chair Blanchfield's comment that maybe this sounds like a city council or a land use activity, but this is really in response to how the application came to us. The district is not the applicant; it's the landowner. So we're actually the only entity that's taking an action on this. So it's really our opportunity, as you see fit, as the membership sees fit, in providing assurances. The 4 bullet points that we've listed, I certainly believe have LAFCO merit. That said, this is up to your comfort level in how far you want to align an applicant with outcomes going forward. Certainly, I would agree that the first two bullet points are the key. 3 and 4, I think, provide those assurances that contemplate to a degree what Mr. Baker was saying, that sometimes bad things happen on slopes, hills, and pipelines sometimes move. And our attempt to create some type of indemnification for the neighbors and protections was there. But again, this is new territory, and staff may have overreached, and that may be the consensus of the commission.
So, just for my own understanding and clarification, you kind of mixed staff and legal counsel.
Yeah.
And so I'm a little bit between those two. Presumably legal counsel has given due consideration to the points. We haven't heard from legal counsel, and certainly understand the points you've made, but in weighing these, at least through my eyes, I'm left a little uncertain. I don't want to return it, quite frankly, but I'm left a little uncertain as to whether or not we should be relying upon our counsel when viewing this matter, and yet without that direct input, it's a little difficult to do so. So I'm troubled by this, to go counter to counsel, and it's not a reflection certainly, but gee, there's no way we pay them. And you've concluded after your discussion with our legal counsel that these are most appropriate.
Yes.
So the foundation for the decision to run counter to that is difficult for me. And I would suggest for this body, quite frankly.
Yeah. So I'm not clear when there was, if there even was a meeting of the minds between the three parties on the 4 bullets. Was it, I'm getting that between you, Keene, and our outside counsel, there was a meeting of the minds.
Yes.
There was a discussion with Mr. Skelton, but I'm not sure, and maybe he can tell us now whether or not he at that time agreed that, yes, we can go with the 4 bullets or not.
There was no agreement or meeting of the minds regarding the 4 bullet points. These were presented to us after I objected to what I perceived to be an overreach and an impermissible exaction. And specifically, points 3 and 4 have been and continue to be objected to.
Okay, Commissioner Arnold?
I'd like to hear from Mr. Devine, too. Could we do that?
Yep.
Sure.
Yep.
You're-
Yeah.
You can ask for him.
Before I bring Mr.
oh.
Devine to identify a couple of points, I want to just reflect on some of the comments that have been made. One was this pipe will be an orphan. And yes, it would potentially be an orphan. I just dealt with an orphan situation last month where a sewer pipe, had been capped by a neighboring property owner, and it hadn't been used in 12 years. We are now repurposing that pipe and bringing it back up to code, and it's going to be used. And in that case, it's going to be used for a second unit. And it doesn't flow with gravity. It's being pumped, and it's going to be outlet to a different main. And so I don't know what the future holds, but what I'm saying is not to foreclose the future or unreasonably burden the future with some conditions that simply are not reasonably related or roughly proportionate to the impacts that are being connected to this project. Another point was talking about the public interest. Moments later, the public interest was defined as 4 or 5 property owners. That is not the public interest. The public interest is a global theory, looking out and being paternalistic for 4 or 5, actually in this case, property owners who I have to believe were noticed for this hearing, for the prior hearing, and elected not to come, not to write correspondence, not to object, not to even opine on the conditions and say, yeah, do that. That's going to really help us out because we didn't actually think about, or our predecessors in interest didn't think about the insurance, didn't think about the indemnification. Those issues, that is not the public interest. That is a paternalistic view and an impermissible exaction for the benefit of a limited number of owners. Commissioner Conley's questions about LAFCO liability and the effective management of government services being a broad net that's trying to sweep this into the purview of the commission, I think is exactly on point. At the outset of your prior public hearing item, or excuse me, at the tail end of the prior public hearing item, there was some discussion of Corte Madera and Larkspur and their fire departments maybe consolidating. And Keene aptly said, is this a functional consolidation or a political consolidation? If it's a functional consolidation, it's not your issue. It's not. They can do what they want to do. They form a JPA. They want to, effectively manage their fire and make it more cost effective. That's up to them. But if they're talking about politically consolidating units, yeah, that's for you guys. You can wrestle with it, impose conditions, and review that criteria. That's very analogous to this situation here. All right, we don't have a political consolidation with these private property owners. It's a functional issue that remains a private property issue. And then to Commissioner Murray's point about being married and having two wives, I appreciate the concept because I thought about it, and we're asking for a divorce, and we want to hook up with Las Colinas. But that doesn't mean we can't have a relationship with San Rafael Sanitation District. As long as there are checks and balances, as long as we cap the pipes.
You're being taped.
Yeah. And so you're right. We cannot have our cake and eat it too, and we're not asking for that. We're asking for a reorganization. We want to be gravity fed, but we don't want to foreclose the opportunity to go back and if necessary, reapply to this commission for a change of circumstances and a reorganization. And it would be a more painless process because the infrastructure would already be in place. And ideally, it would be in place without burden restrictions like filling it with grout or some other heavy material, which would be costly to remove and restore. I have one other point to that. I'll defer to Mr. Devine because he has firsthand contact with the soils engineer, and I think that he would be best appropriate to talk to that or any other questions you want.
Okay, Commissioner Arnold, you have a question, Mr. Devine?
No, I wanted to have him respond to anything that he has heard now.
In
if he
addition.
could. Yeah,
Yeah,
thank you.
and not to repeat what
Right.
your able counsel is.
I'm not going to repeat what he said. I've stepped aside from the last meeting because it became clear that it was not something that I could handle. It was legal issues, and it was appropriate to step aside. I will say this, some miscommunication has obviously happened. I don't think anybody's particularly at fault, but I do not believe there was contact between the two attorneys, and apparently Keene thought there was agreement. I never thought there was agreement, but I left it out there, and that's become clearer tonight. It's being worked out. That's good. What I wanted to speak to is one item, which is where we last had substantive conversations at the end of the meeting in October, I think, which was after I think Mr. Baker raised the issue of the pipe and maybe filling it, and I had said there were problems. He said grout. I remember that. At that time, I was thinking we had a 3 or 4 inch pipe. That's part of the reason I gave this to Chris and the pictures to just show that I was shocked when I saw it. I said, oh, this is completely different than I pictured. I hadn't seen it before. And I contacted, and I wish I had it, but if we have to continue it, I will get a letter from the soils engineer and from the civil, both known quantities. Miller Pacific is a soils engineer. This hill is nothing but rock. We've done 200 lineal feet of 7 to 14 foot high retaining wall, and it sits on rock. It's the slide problem that caused this attachment to San Rafael, that's now going back to Las Colinas, had to do with a burst water main that washed away the septic system, and that it's not bad soil. But we can get the documents to show that. I then called them and asked, well, if it's only an 1.5-inch pipe, what do we do? Digging it up would seem to be causing more disruption, in addition the landscaping and whatever of other people. And Eric DeBanion at Miller Pacific said, you just cap it. It's going to last forever. Forever doesn't mean forever, but for a really long time. They didn't have the black version. They only had the yellow gas version, but it's the same pipe. And Art Smith and Irv Schwartz, that's the engineer on this project. There are others, but they're known engineers, said, you cap it. That's the best way to deal with it. You don't disrupt anything. It's going to last better than a tree root of that size. It's going to just be there forever. So in the public interest, I agree that's an issue. But it really is no longer an issue. I would argue you might feel differently. That's really all I wanted to add.
Okay.
And I have one point of clarification.
Now, okay. I think I would advise you not to clarify that point right now.
No, not on his points. For the condition of the bullet point number 2, I would propose eliminating the second half of the sentence. The applicant, if you're inclined to approve bullet point number 2, the applicant and any successor will maintain the existing sewer pipe within the easement, period. To avoid damage in surrounding properties in perpetuity until the lines are removed, that's superfluous.
Okay, so
yeah.
from your standpoint, you would put a period after easement and strike the rest of the sentence.
Yep.
And that's something that Commissioner Conley would have to consider as to whether he wants to add that to his motion or not.
Okay.
Let me look at it for
And let
10
him look at it for a
seconds
minute.
here.
I do have a member of the public who'd like to speak. We do have a motion and a second on the floor to move us along. I'm going to call for a vote on that. If that succeeds, the matter is finished. If not, then we got some more work to do, and it may be that it's after this meeting.
Shouldn't we hear
I,
from the
I will,
public?
I will accept the proposed modification.
Okay.
We should hear from the public, Mr.
That-
Chair.
Yes, that's what we're going to do.
Okay.
We're going to hear from the public. After that, I want a motion to close the public hearing, and then we'll...
Okay, great.
Okay. I understand there is a member of the public, I don't have the name, who would like to speak to the commission on this matter, and if you would care to,
Thank you, Mr.
give your
Chairman.
name for the records.
Bell, 29 Oak Ridge Road, a property owner in Los Ranchitas. First, I want to say I support the purpose of why this is being done, and I know the area, and I think gravity feed, just engineering-wise, that on that aspect of it is correct. I agree with Commissioner Conley's comments on the bullet items. Just seem a little too extreme, and he's more of an expert at pointing out why than I am, but I caught the gist of it. But number 2 is a practical matter. My background is mainly aeronautical engineering, but if I could, through the chair to Commissioner Baker, I agree with what he's saying, Commissioner Murray, not only about settlement and movement, but over time you have problems with II. As the pipes get old, you get stormwater intrusion. That's unintentional. But the one that's really been a concern to me, and I work closely with the water agency and the Pen Grove Sanitation District, is I've seen time and time again, we talk about repurposing. I've seen them repurpose for gutter, for taking stormwater runoff off of properties, and it ends up down at the treatment plant. And I've seen it again and again and again. And as counsel said, I agree with his comment about public interest. That's ideological. But as a practical matter, who pays for that? It's the ratepayers. The ratepayers end up paying for that when it's abused like that. So I support grout, is what I'm saying. I think it should be filled. Lastly, once the commission works through the particulars of this application, and when I watched the tapes in December, it was my understanding that there are some other homeowners right in that vicinity at Glenside with a similar arrangement of pumping into San Rafael.
I think there was one or two.
And if that's the case, once this is settled, will this be a template in the case that they want to do this? Is this the example that they'll be going by? In other words, will this be available to them? So,
Okay.
thank you, Mr. Chairman.
Thank you very much. I will entertain a motion to close the public hearing if there is no one else in the audience that would like to speak to the commission on this matter.
So move.
Second.
Motion and a second to close the public hearing. All those in favor signify by saying aye.
Aye.
Aye. Any commissioner opposed? Any commissioner abstained? The public hearing is closed. We do have, Commissioner Condon has a comment, and then we'll move to the motion.
Yeah, I have a comment. Just in the past, I'd say 6 months, I've seen probably about a half a dozen horrible damages that have been caused by a benign little pipe. And when I'm looking at the fourth bullet, the applicant and any successor indemnifies the owners of adjacent parcels for any damage caused by the pipes. I could easily make the findings for that. I just, having seen in the past, 6 weeks maybe, seen 2 homes slide down the hill because of something very, very, really just not even noticeable. And so I think that there is a lot to this, rather than just something that might be a convenience. But I think that there's a lot of liability involved in this, and I'm not sure whether it is LAFCO's domain or whose domain it is, but if it comes to relieving any liability for an easement, then I would think it is LAFCO's. But I don't think that it should be looked at as something trivial. I don't think it's a trivial matter at all.
Okay, thank you. Chris, did you have a comment?
I had a question. Hypothetically, what happens if the motion or some variation passes?
Then
There's
the
a
motion-
change. There's a change of sphere of influence, and Las Colinas says, "We're not going to hook you up unless you do the following." And the landowner goes, "Whoa! I don't want to do that." And San Rafael says, "We're not taking your effluent anymore. You're not in our sphere of influence." I mean, what happens when there's this interregnum in here where all of a sudden, I mean, Las Colinas clearly has a lot of powers that arguably we may not have. You can condition the grant, Las Colinas could condition the grant of a hookup on a line on all kinds of things. And what happens if the property owner says, "I'm not going to do that. That's too onerous." And he's now in their sphere of influence, not in San Rafael's. That's a rhetorical question. I don't know.
Chair, if I may, there is an answer to the rhetorical question. There is a safeguard in the resolution that essentially requires staff to hold on actually recording the boundary change in the reorganization until all the Ts are crossed. That would be a big T.
Thank you for the T identification there. Okay, I'm going to move to the motion, and perhaps Commissioner Conley, you could restate it for us so we know what we would be voting on.
Well, I think simply put, and I think you stated it earlier, so the motion would be to approve the requested change in sphere of influence, subject to compliance with bullet points 1 and modified 2.
Okay, that's basically it. And the the language could be fluffed and buffed after this, but this is the major intent. Okay. So we have a motion and a second. All those in favor signify by saying aye. Aye. Could we do a raising of hands so we can count them, please? All those in favor signify by saying aye.
Aye.
Okay. Did you count?
Yes.
Good. And the total is
We have 6 in favor.
6 in favor. Okay, the motion passes. And we will,
Were there any opposed?
Oh,
You would think.
Well, so you had a vote of
Okay.
6. You
how
could,
many we got? 1, 2.
the chair asked for a vote of any
Yeah.
opposed.
Okay, any opposed?
I oppose. I don't think it's stringent enough.
Okay, so we have one opposed. Commissioner Condon opposed. Any abstaining? No, so it's a vote of 6-1 of approval.
So thank you, Commission.
Conditions.
And that covers both of our resolutions, as Commissioner Connolly put in his motion for the sphere amendment and the annexation. The annexation with the modification to the resolution that puts a period in bullet point 2 after easements and strikes bullet points 3 and 4. And just so we know that Mr. Skelton and Mr. Devine, they're fine. Thank you so much. And
And it strikes the remainder of that sentence after easements.
yes.
And okay. And you'll insert that language in the resolution that's attached.
Yes.
So it's consistent.
Thank you so
Okay.
much.
Thank you. Item number 10, this is the scope of analysis for the San Rafael Lucas Valley Regional Study that we've already seen before, and
Although I had to say I had a question on this item and that I didn't have any materials on it in my packet.
I think
So I
that
think that-
is uniform.
That's a problem.
That is a problem.
Yes. Let me ask, is it going to be a problem to carry this over to our next meeting?
No.
Okay, and in that meeting, the packet will be complete when it reaches your
Are there
home or your
materials
office.
that would?
Yes.
Oh, okay, great.
Okay, financial audit.
I'm sorry, Chair, just because I know we have one member from the audience, even though
Okay.
we're going to continue it just to open the hearing and check in if our one member from Marinwood wanted to address the commission.
Sure, that's fine. We'd be glad to hear from you. Maybe you got the, no. Well, this ought to be entertaining then.
It's certainly not going to be as eloquent as your previous speaker. My name is Stephen Nessel. I'm from Marinwood, and thank you very much for the opportunity. Since I don't know too much about this item that you're going to consider, I'm just going to make my comments brief. I learned that there is going to be a study, and I'd like to save everybody money and a little bit of grief. Marinwood has had a history, as many of you know, of being courted, or we've talked about annexation in the past, and there are very few things that join the newcomers with the old timers, and that is annexation to San Rafael. Now, we are dating, though. That's the good news. We just don't want a forced marriage. We are involved in a fire contract with them, and I guess what I'm saying is we don't want a forced marriage. We're certainly open to the ideas of becoming more efficient together, but thanks, but no thanks. We don't want a matchmaker. So that's it.
Mr. Nessel, thank you. Okay, now we will move to agenda item number 11, which is the financial audit for the current fiscal year. Past fiscal year.
Yeah, well, yes, past fiscal year. So as reference for your formal review and file, we are presenting the audit report on Marin LAFCO's financial statements for 2014-15, a report that we did intend to bring to you about 6 months earlier, but our key bookkeeper was on leave, so we apologize for the delay in getting this item to you. But nevertheless, the report was prepared by R.J. Riccardi and Associates out of San Rafael, and while we hope our agenda report does a good job of summarizing the key points, there are three items that I do want to flag for the Commission's benefit, all, I think, certainly relevant to your long-term interest. First and foremost, this is good news. We got a clean bill of health. There were no errors or omissions identified in the statements for 14-15, which certainly gives, with credit going to Candace. And then number two, we got a pretty good audited fund balance. Our audited fund balance, less any pension liabilities, and I'm going to come back to that topic in a second, came in at $196,000, which for our agency and for our budget is a pretty good number, and certainly well above that 20% reserved operating expense threshold that this commission seeks. So again, that is good news. Now, as for the final and third point, and this is neither good nor bad news, it just simply is what it is. This is the first year that governmental agencies, and specifically 14-15, that we needed to start showing our pension liability on the fund balance. And in particular, there are two types of pension issues that you'll see on the balance sheet, which I believe is page 7 under the adjustments. First, all government agencies under GASB 68 are now required to identify their net pension liability, meaning what, as of the date of the report, which in this case is 14-15, is our existing pension debt, and for us that means our portion of the debt with MSERA. So that's one issue. The other is we have to go a little further out and project what is our deferred inflow going forward, meaning what is our likely calculated pension debt over the long term once the auditor takes into account all the smoothing that goes into it. So that is why when you look at our balance sheet, you will see a couple of deductions that ultimately adjust our fund balance from that very clean and positive $196,000 amount down to negative $111,000. Now keep in mind, this is just a telegraphing tool. We're no worse off than we were a year ago. We're just simply taking what was once in the notes and footnotes and now putting it on the balance sheet. And just for the benefit of a measurement that I think we can go back to back to each year going forward, one of the emerging benchmarks that governmental agencies are using to assess their net pension liability is to match that up against annual payroll. And the goal is if you could stay at 1.0 or under, you're in pretty good shape. And so as we provide in the kind of the cover agenda report, our net pension to payroll ratio is 0.66, which is pretty good, all things being considered. So again, yes, we have pension liability, but certainly it's manageable, and it is what it is, I guess, in that sense. But that said, this is for you to formally receive and file, and again, credit to Candace for keeping our books in order.
Keen, one question. The last page of the report from Riccardi Inc. It says we recommend LAFCO develop, maintain an up-to-date accounting, administrative policies, and procedures manual. I thought we had adopted at least some administrative procedures in response primarily to their last report to us, which was well taken.
Wonderful memory, Chair Blanchfield, and the chair is referencing the management letter that goes with the audit. So yes, a few years ago, they noticed that we didn't have any formal policies or procedures with respect to accounting and everything that goes with it, fraud prevention, whatnot. The policy committee did present, and the commission did tentatively approve procedures, but the auditor noted tentative and formal adoption is different,
Okay,
hence the letter,
so it's pending, and so that needs to get to the commission.
which you will see at the next meeting.
Okay, okay, thank you. So our action today is to note and,
I move we
file.
receive the report.
okay, we have a motion that we've actually received the report, the one in front of us, and a second.
Second.
And we will file it. All those in favor of filing it, please signify by saying aye.
Aye.
Any commissioner opposed? Any commissioner abstaining? The report is hereby filed. Legislative preview for 2016.
That is me, and on behalf of our legislative committee, if you give me 1 second, I too struggle with our copying system a bit here.
Yeah, there's some letters that went with the missing packet.
Well,
that are
this is no
integrated.
excuse, but we are still unpacking boxes, and I
Sure.
think you're seeing a bit of the reaction to that. But on behalf of the legislative committee, which includes members Baker, Condon, and Caius, we have before you an update, essentially, on those bills that are making their way through Sacramento as part of the second year of the 2015-16 session that have some impact on LAFCO, whether they be certainly direct impacts on the law that we operate, the Cortese-Knotts-Hertzberg Act, or laws that we help to administer, like general plan or zoning laws. And as we provide in the report, this is proving to be a pretty busy year for LAFCOs. Not only do you have a quantity issue, there are over 30 bills right now that have some core nexus to LAFCOs that are in various stages of the legislative process right now. And those items are all captured in the Cal-LAFCO report that we prepared or copied to your packet. But through the committee, there are 4 specific bills we just wanted to touch upon with the commission tonight that we think certainly raise to the level of your attention and ultimately to consider some position recommendations. And these are Senate Bill 1266 from Senator McGuire, Senate Bill 1318 from Lois Wolk, Assembly Bill 2471 from Cork, I believe, out of Alameda, and then Assembly Bill 2910, which is just the annual omnibus bill from the local assembly committee. Now, just to kind of cherry pick the most important, Senate Bill 1266, this is your brainchild, Commission. This is the bill that you asked Cal-LAFCO to think about, and through Commissioner Arnold, Senator McGuire has now carried. This would make standalone joint power authorities, not exercise of joint power authorities, which is different, but standalone joint power authorities start to file their agreements and amendments with LAFCOs, with the value to LAFCOs that we get a good accounting of the actual municipal service providers within the county, and then for the public's benefit, when they look at our repository of local government, they get a little more enhancement out of that. And so this bill cleared unanimously through the Senate Committee on Local Government last week, and all signals suggest that this will be a success. And certainly, while the Commission has been supportive of this, we are asking that now that it's a formal bill and amendments are coming, that you officially support it and you authorize a support letter, a new support letter. And the committee was complete unanimously in line with that recommendation, though maybe to different degrees. Now, second to that, a bill of a little more challenge for you is Senate Bill 1318. And again, that's from Lois Wolk, who, as I understand it, represents the Davis, West Sacramento, and some parts of kind of the northern Central Valley. And this is somewhat of a doozy. Senator Wolk is notable for LAFCO in LAFCO circles because a few years ago she passed Senate Bill 244, and that introduced this whole discussion of DUCs, disadvantaged unincorporated communities, into our lexicon. And existing law has us do quite a bit about ducks. In particular, anytime we do a service review, anytime we do a sphere of influence update, there are these progressions we need to do with respect to contemplating and identifying ducks. And just for the benefit of definitions, a duck is defined under state law as a defined area, whether it be through census or other local means, that has a median household income of 80% or less of the statewide average. And I think right now the statewide average is about 55,000. So any area, defined area that has a median household income that falls under, let's say, 48,000 or 45,000 would be considered a duck. And in Marin County, there are two ducks. There's Marin City, and then, for whatever reason, there's Alto. And the committee spent a little time this afternoon talking about Alto in Marin City and this bill. And what we're suggesting right now is this bill makes us somewhat nervous, and I'll tell you why. It would require LAFCOs to, first of all, not only explicitly prepare municipal service reviews every 5 years, that's somewhat already our responsibility, but it would expand that requirement to say to LAFCOs, you need to look at all services, not governmental, it says all services within the county every 5 years. That is suggestive that the author anticipates us looking at things like, well, sheriff services, broadband services, things that might not necessarily be on our radar. So that's the first thing that we certainly would want some clarification on. The second and perhaps more alarming issue is anytime LAFCO prepares a municipal service review going forward and we identify a duck, this law would tell us we have to come up with a plan to eliminate that duck, and that would include presumably addressing infrastructure issues and funding issues, things that seem somewhat out of our expertise. And the bill goes further to say, LAFCOs, if the issue still exists 2 years after you do your report, well, then you are to take action to remedy that issue. Now, what that means, the committee does not know, but certainly it suggests a far more proactive involvement in LAFCO and things that, again, whether it be engineering, state funding, are just kind of outside of our normal operations. And then last but not least, it tells LAFCOs that if you want to provide, or if a city or district wants to provide services outside of its jurisdictional boundary, but there's a duck next to this affected area, you either bring it all in, the group of people who want to be annexed or served, plus the duck, or you can't do it at all. And I know that speaks to, the idea of kind of tying LAFCO's discretion quite a bit. So for these reasons, your legislative committee is recommending that the commission oppose unless amended, and specifically the amendments would be focused in on providing LAFCOs more discretion to deal with local conditions, as well as to help us better understand what exactly do you mean by plan of service and what exactly do you anticipate LAFCO being able to do in implementing a plan of service. The other two bills are a little less significant, but still have some substance. If I was Marin General Hospital, I would certainly be interested in AB 2471. That's the bill that says under certain criteria, LAFCOs, you are to dissolve a healthcare district. The criteria being if a district received property taxes and has a significant reserve, but also doesn't directly provide a healthcare service, which I know sounds kind of counterintuitive, but apparently that does happen in different places in the state. This bill would tell LAFCOs you are going to dissolve that district and you're going to waive protest proceedings. Apparently this issue came up in Eden Valley in Alameda, where the author is from. LAFCO did a service review of the Eden Valley Healthcare District, and while, as I understand it, noted there were some oddities about its operations, chose not to act on initiating a dissolution. That did not go over well with the author, who was a LAFCO member at the time, hence the bill. as the committee will attest if they want to go into more detail, again, it seems like a rather broad stroke for all LAFCOs to be kind of forced into consolidating something, let alone defining what is a significant fund balance for a healthcare district. So we're recommending that you oppose that bill, and again, unless amended, to provide some discretion to LAFCOs. Parenthetically, though, this is a trend, right? You're having more and more LAFCO commissioners who either had a great experience on LAFCO or perhaps not the best experience on their time at LAFCO, who go to the Senate or the Assembly, and they're bringing forward bills that either expand LAFCO's powers perhaps beyond where they should be, like Senator Wolk, or, in this case, Assemblymember Quirk perhaps felt LAFCOs don't do enough and is now going to force the hand. So I think this is a trend we're going to see more and more, especially with term limits. And then finally, Assembly Bill 2910, that's just the annual cleanup bill to LAFCO law. One of the things, and this is pertinent to Chair Blanchfield and Commissioner Burdick, there's an existing blind spot in LAFCO law that no one really noticed before as it relates to public members. And the existing blind spot is it doesn't actually specify, unlike the rest of you, that you need to be a resident of the home county. So that is one of the cleanup items in this bill. We're going to make, that's right. From here on out, you better be a resident of the home county. But just again, non-technical but needed changes and just a recommendation to support. So in short, a recommendation to support 1266, a recommendation to oppose, unless amended, both AB 2471 and Senate Bill 1318, and support for AB 2910.
Commissioner Arnold.
What are the two ducks again in Marin County?
So as of the 2010 census, you have Marin City and you have Alto. Now these are
Alto is in Mill Valley?
It is right
it's
outside.
adjacent to Mill Valley. It's
Adjacent.
unincorporated.
Right,
It's actually in
okay.
the county.
Interesting.
We were surprised at that.
Yeah.
Lou's gonna check on this.
That's hard to believe.
Or that they're in Alto.
I mean, I would think the canal would be the canal.
Well, the canal is in a city, so
that's
it
right.
goes outside
Yeah.
of the legislation.
Well, so I would suggest that what you want to do on the AB or the SB 1318 is just to say monitor, not to say oppose. And the reason that I say that is because right now the federal government is looking at Marin, especially HUD, with a magnifying glass, and how we treat, whether you call them the unprotected classes or the Title VI people or the ducks, often it doesn't look good. And I just would say that we can end up opposing it, but I would change it right now to monitor.
I'll defer to the rest of the committee
Yeah.
for
It seems
input.
reasonable to me.
Would you like a motion? Oh, Craig has his hand
I'm
up.
sorry, Craig.
Yeah, actually on 1318 too. So Keen, my concern is all legislation coming forward that's unfunded mandates, and it seems like it would be a typical one, just on the face of it, to oppose,
Yeah.
rather than forcing this on the locals. So if we do change this,
We could still
to-
oppose it down the road.
and we modify that too, that we'd like to see some funding and support at state level if these are truly concerns.
I'm fine with that.
Carla, you had a...
Yeah, well, we discussed this, we had discussed this, and I still think that, I'm concerned that the monitoring is letting the horse out of the gate. And I think that what we had, the provisions that we had added, the provisions to amend, I really thought were very clear, and that it still allowed equitable treatment for the whole issue. And I know where you're coming from, Judy. But
I'm
I
worried
s-
for all of us, for the
but-
cities, for the county. I just think monitor is a word that's used a lot in cities and in counties when they do legislative opinions. We could end up opposing it if these things don't, because it is a very nebulous bill right now. There aren't a lot of specifics. But I just think if we,
Or even propose amendments if we care to.
where is it right now in the legislative
Well,
process?
right now, it's that you can't
No, I mean,
address your infrastructure
No, but
until.
is it before, what committee is it?
So
know
it
what
passed through Senate Committee on Local Government on party lines, and right now it's going to, I forget it's not appropriations, but there's a new Environmental Justice Committee. So you have another probably month and a half to 2 months before it goes to Assembly. That's the next big
So it's early in
hearing.
the process, is what I'm saying. It might get amended in some more committees.
So could you report back at the next meeting of its status?
Yeah, sure.
I mean, that's 2 months from now.
I'll defer to the committee members on their preference on this.
Well, I just think that it's important that everyone's aware that what's in the bill right now does not permit a jurisdiction to make any improvements on their infrastructure until any duct is addressed and brought up to acceptable level. So even in case of an emergency, and with another infrastructure, it can't be addressed at all. It only can be, infrastructure can only be addressed in terms of the duct. And I think that can really impede emergency type issues that come up. I think it's, I just think it's not fair.
But we're talking about Marin City.
Well, we're talking about in general. This doesn't just apply to Marin. This applies
Well, but
statewide.
we're looking at Marin right now. That's all I'm saying. Well, I hear what you're saying.
Yeah.
I mean, if it would help, I'll make a motion and we can vote it up or down.
I'll second Judy's
Okay.
motion.
Okay. Any other comment on that? We'll put it to a vote. Then Judy, your motion would be
We just change it
the language.
change it to monitor for now.
Okay.
That's all.
So it would be changing from monitor, and we would do that.
Yeah.
Okay, so
And still can make comments in opposition once we see what's happening.
once it's moving and you see what it's doing.
Or unless amended or whatever.
Exactly.
Yeah.
Yeah, exactly.
Okay. All those in favor of the motion to change the language to monitor, signify by saying aye.
Aye.
Any commissioner opposed?
I would just comment too, we talked about this at the committee meeting
Yeah.
earlier. I'm not a big fan of it as it stands, and
I
I
know.
really do share
Yeah.
Carla's concern, even though we don't have the same exposure as some parts of the valley or East Bay may have, just it's Marin City and Alto, apparently, to our surprise. But
weird.
anyway, it does look like we have time to take a position opposing or amending or something down the road.
Yeah, and that's one of the things we'll be focused on too, is just not saying it, we'll follow up on that.
Exactly.
And the legislative committee is primed to follow that now. Okay, so we had a motion and we had a vote, and there was no opposition, no.
But I'll move to approve the other recommendation.
So, second,
Yes,
I'll
okay.
second that.
Okay, we have a motion, second to approve the other 1, 2, 3 recommendations. All those in favor signify by saying aye.
Aye.
Any commissioner opposed? Any commissioner abstaining? That motion passes as well. So Keene, is that it until next meeting? Yes. Okay, and we will be monitoring the bill that we changed the language, or like a hawk, of course. I didn't know hawks monitored, but that sounds.
You do.
Okay, report from the Cal LAFCO annual workshop.
That will be me. I'll make this quick. I would just like you to reference, or I'm referencing this Cal LAFCO letter submitted by our executive director, Pamela Miller. It should be in your folder. She just wanted to thank the commission for allowing staff to attend the workshop. She understands that budget constraints and resources may be limited. She wanted to ensure that staff are accessing professional development opportunities and specialized education opportunities through this workshop. This was my first workshop. I was thoroughly impressed by it. I know Los Angeles County hosted. It was at Universal City. There were some great panels from tips on conducting protest proceedings to improving LAFCO website experiences or updating the website and building team trust or creating good teams. So I just want to thank the commission as well, and it was a really good workshop.
Great, thank you, Rachel.
Can I ask Keene a question?
You may ask Keene a question.
Keene,
Whether he can answer it is to be determined.
I have a question to put you on the spot. Did you submit your wonderful water study to Cal LAFCO?
Not yet. So Commissioner Condon was nice enough to suggest every year Cal LAFCO does its awards. And before Commissioner Baker could make the suggestion, Carla had come up and said, you know, the Project of the Year award, why don't you submit the water study? And we will do that. I think in fact, you'll formally pick that up at your next meeting along with any district or city members who might want to run for Cal LAFCO board, as I make eye contact with some of you. So, but thank you again. That was a very nice suggestion. So we are going to do it.
Good.
Good. Yes.
Also, not to put you on the spot, but it came up in one of the other groups I'm involved in, specifically the sanitation district. How did we come out? Because I don't recall on the grand jury report for website.
You know, interesting enough, LAFCO was spared any specific
That's why
involvement.
I don't remember it.
But we were queried a bit. So I think last month the grand jury came out, and it's been one of their topics for the last few years about website enhancement, and I think they gave grades this time. I can't even recall what the grades are for some of our appointing authorities here, but LAFCO, a lot of Fs? Yeah, so LAFCO was spared.
Yeah. Well,
I think they just viewed us. I think they did view us as the alphabet, one of the alphabets. They made a preface that they were not going to review any of the alphabet agencies. So sadly, we're in that.
So
category.
there was no review at all of LAFCO.
No, not on the websites. Whether or not another report comes out, I don't know.
Okay. Yes.
Yeah, so I just, on that point, I did make a note to speak on this too, so I thank Commissioner Phillips in bringing that forward. LAFCO has made tremendous efforts, and that's due to Keene and Candace, and I know our newer staff, Rachel, and others will be improving on it to make great steps. So it was a little disappointing. I actually was perusing that, looking for LAFCO, because I saw Las Colinas and Novato, others in the A categories, and I thoroughly thought we would be an A+. And so I was a little disappointed that wasn't in there. And I think it would reflect well on staff and as well as this commission. So without that approval by the grand jury, I would, just as a commissioner, like to thank staff for putting together an excellent website, and I think it shows well.
And credit goes to Candace. It's really her activity at LAFCO.
Is this the new website or the one that we said was terrible, so we hired somebody to.
The current website's not terrible at all. It's just it's predicated on software called Joomla. And for those who are familiar with Joomla, it's a community-based application from Norway. So young kids in Norway got together. They created a free application.
Stop it.
For some reason, we put all our ducks in this Norwegian
all the ducks
system.
We'll monitor 'em, please.
So when the 16-year-old is busy, we have trouble getting updates on our technical issues.
Well, if you follow my suggestions on that software, remember, it's from New Zealand, so you can't go wrong.
And what did the grand jury think of the logo?
Again, sadly, they did not look at that, but I do know, and Rachel will attest to this, it does well. In fact, Rachel, when you first saw it, you said, wow.
I want to work there.
Yeah.
Well, you can submit it to the Cal LAFCO for an award, I'm sure they'll. Okay. Well, this gets us to adjournment, I guess, unless you have a report, Keen.
None. Thank you so much.
Move to adjourn.
Second.
Motion is second, we are adjourned.